Please be seated. The sitting is open. The court meets today pursuant to Article 58 of its statute and Article 94 of its rules to read out in open court its judgment on preliminary objections in the case concerning alleged violations of the 1955 Treaty of Amity, economic relations and consular rights, Islamic Republic of Iran versus the United States of America. In view of the current COVID pandemic, the court has opted for a hybrid format for today's sitting. 6 judges are present with me in the Great Hall of Justice, namely Vice President Shue, Judges Tomka, Abraham, Sebutinde, Gevorgian, and Iwasawa. 7 judges are participating in the sitting remotely, namely Judges Benuna, Cansado Trindade, Pandari, Robinson, and Salam, and Judges ad hoc Brower and Momtaz. For reasons made known to me, Judges Gaia and Crawford, who duly participated in the deliberations and final vote in this case, are unable to sit with us today. I will now read out the judgment in the present case. I recall that the proceedings in this case were instituted on 16 July 2018 by the Islamic Republic of Iran against the United States of America with regard to alleged violations of the Treaty of Amity, economic relations and consular rights, which was signed by the 2 states in Tehran on 15 August 1955 and entered into force on 16 June 1957, to which I will refer as the Treaty of Amity or the 1955 Treaty. In its application, Iran sought to found the court's jurisdiction on Article 36, Paragraph 1 of the Statute of the Court and on Article 21, Paragraph 2 of the 1955 Treaty. On 23 August 2019, within the time limit prescribed by Article 79, Paragraph 1 of the Rules of Court of 14 April 1978, as amended on 1 February 2001, the United States raised certain preliminary objections. The proceedings on the merits were accordingly suspended. In accordance with the usual practice, I will not read out the introductory paragraphs of the judgment, which set out the main elements in the procedural history of the case. I will also omit some paragraphs and summarize others. I will therefore begin reading the judgment at paragraph 24, where the court begins recounting the factual background. The full text of the judgment will, of course, be available at the close of the sitting. With regard to the factual background, the court recalls that Iran alleges violations by the United States of the Treaty of Amity. It's not disputed by the parties that on the date of the filing of the application, namely on 16 July 2018, the Treaty of Amity was in force. The court further recalls that Iran is a party to the Treaty on the Non-Proliferation of Nuclear Weapons of 1 July 1968. According to Article 3 of this treaty, each non-nuclear weapon state party undertakes to accept safeguards set forth in an agreement to be negotiated and concluded with the International Atomic Energy Agency, to which I will refer as the IAEA or agency. The agreement between Iran and the Agency for the Application of Safeguards in connection with the Treaty on the Non-Proliferation of Nuclear Weapons has been in force since 15 May 1974. In a report dated 6 June 2003, the IAEA Director General stated that Iran had failed to meet its obligations under the Safeguards Agreement. In 2006, the agency's Board of Governors requested the Director General to report the matter to the Security Council of the United Nations. On 31 July 2006, the Security Council, acting under Article 40 of Chapter 7 of the Charter of the United Nations, adopted Resolution 1696/2006, in which it noted with serious concern Iran's decision to resume enrichment-related activities and demanded the suspension of all of its enrichment-related and reprocessing activities to be verified by the IAEA. On 23 December 2006, the Security Council, acting under Article 41 of Chapter 7 of the Charter of the United Nations, adopted Resolution 1737/2006, in which it decided that Iran must suspend all enrichment-related and reprocessing activities, including research and development, to be verified by the IAEA. It further decided that all states must take the necessary measures to prevent the supply, sale, or transfer of all items, materials, equipment, goods, and technology which could contribute to Iran's nuclear-related activity. In 2010 and 2012, the Council of the European Union adopted various nuclear-related restrictive measures against Iran, banning arms exports, restricting financial transactions, imposing the freezing of assets, and restricting travel for certain individuals. The United States, by executive orders issued during the period between 2011 and 2013, imposed a number of nuclear-related additional sanctions with regard to various sectors of Iran's economy. On 14 July 2015, China, France, Germany, the Russian Federation, the United Kingdom, and the United States, together with the High Representative of the European Union for Foreign Affairs and Security Policy and representative of Iran, concluded the Joint Comprehensive Plan of Action, to which I will refer as the JCPOA, concerning the nuclear program of Iran. The declared purpose of that instrument was to ensure the exclusively peaceful nature of Iran's nuclear program and to produce, I quote, the comprehensive lifting of all UN Security Council sanctions as well as multilateral and national sanctions related to Iran's nuclear program, end of quote. On 20 July 2015, the Security Council adopted Resolution 2231/2015, whereby it endorsed the JCPOA. It provided in particular for the termination under certain conditions of provisions of previous Security Council resolutions on the Iranian nuclear issue. On 16 January 2016, the President of the United States issued Executive Order 13716, revoking or amending a certain number of earlier executive orders on nuclear-related sanctions imposed on Iran or Iranian nationals. On 8 May 2018, the President of the United States issued a national security presidential memorandum announcing the end of the participation of the United States in the JCPOA and directing the reimposition of sanctions lifted or waived in connection with the JCPOA. On 6 August 2018, the President of the United States issued Executive Order 13846, reimposing, and I quote, certain sanctions end of quote, on Iran, its nationalists, and companies. Having set out the factual background to the case, the court proceeds to examine the preliminary objections raised by the respondent. The United States has raised 5 preliminary objections. The first 2 relate to the jurisdiction of the court, ratione materia, to entertain the case on the basis of Article 21, paragraph 2 of the Treaty of Amity. The third objection contests the admissibility of Iran's application by reason of an alleged abuse of process and on grounds of judicial propriety. The last 2 are based on subparagraphs B and D of Article 20, paragraph 1 of the Treaty of Amity. Although, according to the respondent, they relate neither to the jurisdiction of the court nor to the admissibility of the application, the respondent requests a decision upon them before any further proceedings on the merits. The court begins by considering issues related to its jurisdiction. The first preliminary objection to jurisdiction relates to the subject matter of the dispute. The court notes that the parties do not contest that there is a dispute between them, but they disagree as to whether this dispute concerns the interpretation and application of the Treaty of Amity, as Iran claims, or exclusively the JCPOA, as the United States contends. In the latter case, the dispute would fall outside the scope ratione materia of the compromissory clause of the Treaty of Amity. As the court has consistently recalled, the applicant must indicate to the court what it considers to be the subject of the dispute, in accordance with Article 40, paragraph 1 of the statute. However, it is for the court to determine, taking account of the parties' submissions, the subject matter of the dispute of which it is seized. The court's determination of the subject matter of the dispute is made on an objective basis, while giving particular attention to the formulation of the dispute chosen by the applicant. To identify the subject matter of the dispute, the court bases itself on the application as well as on the written and oral pleadings of the parties. In particular, it takes account of the facts that the applicant identifies as the basis for its claim. According to the submissions presented in its application and its memorial, Iran essentially seeks to have the court declare that the measures reimposed pursuant to the United States decision expressed in the Presidential Memorandum of 8 May 2018 are in breach of various obligations of the United States under the Treaty of Amity. The United States contests that the impugned measures constitute violations of the Treaty of Amity. Hence, there exists an opposition of views which amounts to a dispute relating to the Treaty of Amity. It's true that this dispute arose in a particular political context, that of the United States' decision to withdraw from the JCPOA. However, as the court has had occasion to observe, and I quote from an earlier case, legal disputes between sovereign states, by their very nature, are likely to occur in political contexts, end of quote. The fact that the dispute between the parties has arisen in connection with and in the context of the decision of the United States to withdraw from the JCPOA does not in itself preclude the dispute from relating to the interpretation or application of the Treaty of Amity. Certain acts may fall within the ambit of more than one instrument, and a dispute relating to those acts may relate to the interpretation or application of more than one treaty or other instrument. To the extent that the measure is adopted by the United States, following its decision to withdraw from the JCPOA, might constitute breaches of certain obligations under the Treaty of Amity. Those measures relate to the interpretation or application of that treaty. Even if it were true, as the respondent contends, that a judgment of the court upholding Iran's claims under the Treaty of Amity would result in the restoration of the situation which existed when the United States was still participating in the JCPOA, it nonetheless would not follow that the dispute brought before the court by Iran concerns the JCPOA and not the Treaty of Amity. The court further notes that the United States has made clear that it does not assert that the existence of a connection between the dispute and its decision to withdraw from the JCPOA suffices in itself to preclude the court from finding that it has jurisdiction over Iran's claims under the Treaty of Amity. Nor does the United States argue that jurisdiction under the treaty is precluded solely because the dispute is part of a broader context that includes the JCPOA. The respondent's argument is that the very subject matter of Iran's claims in this case relates exclusively to the JCPOA and not to the Treaty of Amity. The court, however, does not see how it could support such an analysis without misrepresenting Iran's claims as formulated by the applicant. The court's duty to isolate the real issue in the case and to identify the object of the claim does not permit it to modify the object of the submissions, especially when they have been clearly and precisely formulated. In particular, the court cannot infer the subject matter of a dispute from the political context in which the proceedings have been instituted, rather than basing itself on what the applicant has requested of it. For the foregoing reasons, the court concludes that it cannot uphold the first preliminary objection to jurisdiction raised by the United States. The second preliminary objection to jurisdiction raised by the United States concerns third country measures. According to the United States, the court lacks jurisdiction to entertain the vast majority of Iran's claims, as those claims relate to measures which principally concern trade or transactions between Iran and third countries or their respective nationals or companies. By contrast, argues the United States, the Treaty of Amity is applicable only to trade between Iran and the United States or their respective nationals and companies. Iran contests this view. The court recalls that according to its well-established jurisprudence, in order to determine its jurisdiction ratione materiae under a compromissory clause concerning disputes relating to the interpretation or application of a treaty, it cannot limit itself to noting that one of the parties maintains that such a dispute exists and the other denies it. The court must ascertain whether the acts of which the applicant complains fall within the provisions of the treaty containing the compromissory clause. This may require the interpretation of the provisions that define the scope of the treaty. The court observes that the third country measures objection does not concern all of Iran's claims, but only the majority of them. Indeed, the respondent stated that one of the four categories into which it divides the measures put in place or reimposed pursuant to the Presidential Memorandum of 8 May 2018 cannot be characterized as third country measures and is therefore not included in the second preliminary objection to jurisdiction. This fourth category consists of the revocation of certain licensing actions which had made it possible to engage in certain commercial or financial transactions with Iran during the period of implementation of the JCPOA. According to the respondent, the licenses in question, which were revoked pursuant to the Memorandum of 8 May 2018, benefited U.S. persons, and their withdrawal is not included in the objection now under consideration. It follows that even if the court were to uphold the second objection to jurisdiction, and assuming that it does not accept any of the other preliminary objections, each of which concerns all of Iran's claims, the proceedings would not be terminated. They would, in any event, have to continue to the merits in respect of the category of measures challenged by Iran, which, according to the United States, are not third country measures. The court noticed, however, that as regards this category, the United States has declared that it, and I quote, reserves the right to argue that some or all of Iran's claims based on the revocation of particular licensing actions are outside the scope of the treaty, end of quote, at a later stage in the proceedings, should these proceedings continue. The court observes that the parties are in disagreement about the relevance of the concept of third country measures and about the effects that should follow from the application of such a concept in this case. According to the United States, the court should find that it lacks jurisdiction to entertain most of Iran's claims, since the vast majority of measures complained of by the applicant are directed against non-US persons, companies, or entities. Iran, on the other hand, contends that the concept of third country measures is irrelevant. It's only necessary, according to the applicant, to examine each category of measures at issue in order to determine whether they fall within the scope of the various provisions of the Treaty of Amity, which it claims to have been violated. Moreover, the parties disagree on the interpretation of the provisions of the treaty, which Iran claims to have been breached by the United States, as regards their territorial scope and their ambit. According to Iran, the provisions that do not contain an express territorial limitation must be interpreted generally as being applicable to activities exercised in all places. According to the United States, it follows from the object and purpose of the Treaty of Amity that it is concerned only with the protection of commercial and investment activity of one party or of its nationals or companies on the territory of the other or in the context of trade between them. Furthermore, Iran maintains that the treaty prohibits the United States from impairing the rights guaranteed to Iran and Iranian nationals and companies, not only through measures applied directly to those nationals or companies, or to US persons in their relations with Iran, but also through measures directed in the first instance against a third party, whose real aim is, however, to prevent Iran, its nationals and its companies from enjoying their rights under the treaty. The United States contests this view. The court observes that all the measures of which Iran complains, those put in place or reinstated as a result of the Presidential Memorandum of 8 May 2018, are intended to weaken Iran's economy. Indeed, on the basis of the official statements of the United States authorities themselves, Iran, its nationals, and its companies are the target of what the respondent describes as third country measures, as well as of measures aimed directly against Iranian entities, and of those against U.S. persons, which are intended to prohibit them from engaging in transactions with Iran, its nationals, or its companies. However, it cannot be inferred from the above that all the measures at issue are capable of constituting breaches of the United States obligations under the Treaty of Amity. What's decisive in this regard is whether each of the measures or category of measures under consideration is of such a nature as to impair the rights of Iran under the various provisions of the Treaty of Amity, which the applicant claims to have been violated. Conversely, the fact that some of the measures challenged, whether or not they are the vast majority, as the United States maintains, directly target third states or the nationals or companies of third states, does not suffice for them to be automatically excluded from the ambit of the Treaty of Amity. It's only through a detailed examination of each of the measures in question, of their reach and actual effects, that the court can determine whether they affect the performance of the United States obligations arising out of the provisions of the Treaty of Amity invoked by Iran, taking account of the meaning and scope of those various provisions. In sum, the court considers that the second preliminary objection of the United States relates to the scope of certain obligations relied upon by the applicant in the present case and raises legal and factual questions which are properly a matter for the merits. If the case were to proceed to the merits, such matters would be decided by the court at that stage on the basis of the arguments advanced by the parties. In light of the foregoing, the court finds that the second preliminary objection to jurisdiction raised by the United States cannot be upheld. For all the reasons set out above, the court finds that it has jurisdiction ratione materia to entertain the application of Iran on the basis of Article 21, Paragraph 2 of the 1955 Treaty of Amity. The court now turns to the question of the admissibility of Iran's application. The objection to admissibility raised by the United States is based on the contention that, and I quote, Iran's claims amounted to an abuse of process and would work an injustice that would raise serious questions of judicial propriety, end of quote. This is because, according to the United States, Iran has invoked the Treaty of Amity in a case involving a dispute that solely concerns the application of the JCPOA. The court noticed that the United States did not address its objection to the admissibility of Iran's application during the oral hearings, but expressly maintained that objection. As the court has observed in an earlier case, it's only in exceptional circumstances that it should reject a claim based on a valid title of jurisdiction on the ground of abuse of process. The court has specified that there has to be clear evidence that the applicant's conduct amounts to an abuse of process. In the present case, the court has already ascertained that the dispute submitted by the applicant concerns alleged breaches of obligations under the Treaty of Amity and not the JCPOA. The court has also found that the compromissory clause included in the Treaty of Amity provides a valid basis for its jurisdiction with regard to the applicant's claims. In the view of the court, there are no exceptional circumstances that would justify considering Iran's application inadmissible on the ground of abuse of process. The fact that Iran only challenged the consistency with the Treaty of Amity of the measures that had been lifted in conjunction with the JCPOA and then reinstated in May 2018 without discussing other measures affecting Iran and its nationals or companies may reflect a policy decision. However, as was noted in an earlier case, the Court's judgment cannot concern itself with the political motivation which may lead a state at a particular time or in particular circumstances to choose judicial settlement. In any event, the fact that most of Iran's claims concern measures that had been lifted in conjunction with the JCPOA and were later reinstated does not indicate that the submission of these claims constitutes an abuse of process. In light of the foregoing, the Court finds that the objection to admissibility of the application raised by the United States must be rejected. The Court now addresses the objections raised by the United States on the basis of Article 20, paragraph 1b and d of the Treaty of Amity. Article 20, subparagraph 1b provides that the Treaty of Amity shall not preclude the application of measures relating to fissionable materials, the radioactive byproducts thereof, or the sources thereof. For its part, subparagraph 1d provides that the treaty shall not preclude the application of measures necessary for the protection of the essential security interests of a high contracting party. The Court recalls that in the oil platforms case, Islamic Republic of Iran versus United States of America, it found that, and I quote, Article 20, paragraph 1d of the Treaty of Amity does not restrict its jurisdiction in the present case, but is confined to affording the parties a possible defense on the merits, end of quote. A similar view was expressed in the case concerning certain Iranian assets, where the Court noted that the interpretation given to Article 20, paragraph 1 with regard to subparagraph D also applies to subparagraph C, which concerns measures, and I quote, regulating the production of or traffic in arms, ammunition, and implements of war, end of quote. The Court observed that there were no relevant grounds on which to distinguish subparagraph C from subparagraph D. The Court finds that there are equally no relevant grounds for a distinction with regard to subparagraph B, which may only afford a possible defense on the merits. The parties do not dispute that arguments based on Article 20 of the Treaty of Amity do not affect either the Court's jurisdiction or the admissibility of the application. However, the respondent argues that objections formulated on the basis of Article 20, paragraph 1b and d may be presented as preliminary according to Article 79 of the Rules of Court as, and I quote, other objections, the decision upon which is requested before any further proceedings on the merits, end of quote. The applicant contends that subparagraph B, which refers to measures relating to fissionable materials, should be interpreted as addressing only measures such as those specifically concerning the exportation or importation of fissionable material. It was, however, argued by the respondent that subparagraph B applies to all measures of whatever content addressing Iran's nuclear program because they may all be said to relate to the use of fissionable material. The question of the meaning to be given to subparagraph B and that of its implications for the present case do not have a preliminary character and will have to be examined as part of the merits. A decision concerning these matters requires an analysis of issues of law and fact that should be left to the stage of the examination of merit. The same applies to measures taken by the United States, allegedly because they are deemed necessary to protect its essential security interests and are therefore argued to be comprised in the category of measures that are outlined in subparagraph G. The analysis of this objection would raise the question of the existence of such essential security interests and may require an assessment of the reasonableness and necessity of the measures insofar as they affect the obligations under the Treaty of Amity. Such an assessment can be conducted only at the stage of the examination of the merits. For the foregoing reasons, the Court concludes that the argument is raised by the respondent with regard to Article 20, paragraph 1b and g of the Treaty of Amity cannot provide a basis for preliminary objections, but may be presented at the merits stage. Therefore, the preliminary objections raised by the United States based on these provisions must be rejected. I shall now read out paragraph 114, the operative part of the judgment. For these reasons, the Court, 1, unanimously rejects the preliminary objection to its jurisdiction raised by the United States of America, according to which the subject matter of the dispute does not relate to the interpretation or application of the Treaty of Amity, Economic Relations, and Consular Rights of 1955. 2, unanimously rejects the preliminary objection to its jurisdiction raised by the United States of America relating to the measures concerning trade or transactions between the Islamic Republic of Iran or Iranian nationals and companies and third countries or their nationals and companies. 3, by 15 votes to 1, rejects the preliminary objection to the admissibility of the application raised by the United States of America. In favor, President Yusuf, Vice President Shue, Judges Tomka, Abraham, Benuna, Cansado Trindade, Gaia, Sebutinde, Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, Judge ad hoc Mumtaz. Against, Judge ad hoc Prawa. 4, by 15 votes to 1, rejects the preliminary objection raised by the United States of America on the basis of Article 20, paragraph 1b of the Treaty of Amity, Economic Relations and Consular Rights of 1955. In favor, President Yusuf, Vice President Shue, Judges Tomka, Abraham, Benuna, Cansado Trindade, Gaia, Sebutinde, Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, Judge ad hoc Mumtaz. Against, Judge ad hoc Prawa. 5, unanimously rejects the preliminary objection raised by the United States of America on the basis of Article 20, paragraph 1G of the Treaty of Amity, Economic Relations and Consular Rights of 1955. 6, by 15 votes to 1, finds consequently that it has jurisdiction on the basis of Article 21, paragraph 2 of the Treaty of Amity, Economic Relations and Consular Rights of 1955, to entertain the application filed by the Islamic Republic of Iran on 16 July 2018, and that the said application is admissible. In favor, President Yusuf, Vice President Shue, Judges Tomka Abraham Benuna Cansado Trindade, Gaia Sebutinde Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, Judge Ad hoc Mumtaz. Against, Judge Ad hoc Prawa. I shall now call upon the registrar to read the operative part of the judgment in French.
Merci, Monsieur le Président. Par ces motifs, la Cour, 1, à l'unanimité, rejette l'exception préliminaire d'incompétence soulevée par les États-Unis d'Amérique, selon laquelle l'objet du différend ne concerne pas l'interprétation ou l'application du traité d'amitié, de commerce et de droit consulaire de 1955. 2. À l'unanimité, rejette l'exception préliminaire d'incompétence soulevée par les États-Unis d'Amérique relative aux mesures qui concernent le commerce ou les transactions entre la République islamique d'Iran ou ses ressortissants et sociétés et des pays tiers ou leurs ressortissants et sociétés. 3. Par 15 voix contre 1, rejette l'exception préliminaire d'irrecevabilité de la requête soulevée par les États-Unis d'Amérique pour M. Yusuf, président, Mme Shue, vice-présidente, M. Tomka Abraham Benuna Cansado Trindade, Gaia, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge, M. Montaz, juge ad hoc. Contre, M. Brower, juge ad hoc. 4. Par 15 voix contre 1, rejette l'exception préliminaire soulevée par les États-Unis d'Amérique sur le fondement de l'alinéa B du paragraphe 1 de l'article 20 du traité d'amitié, de commerce et de droit consulaire de 1955. Pour M. Yusuf, président, Mme Shue, vice-présidente, M. Tomka Abraham Benuna Cansado Trindade, Gaia, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge, M. Montaz, juge ad hoc, contre M. Brower, juge ad hoc. 5. À l'unanimité, rejette l'exception préliminaire soulevée par les États-Unis d'Amérique sur le fondement de l'alinéa D du paragraphe 1er de l'article 20 du traité d'amitié, de commerce et de droit consulaire de 1955. 6. Par 15 voix contre 1, dit en conséquence qu'elle a compétence en vertu du paragraphe 2 de l'article 21 du traité d'amitié, de commerce et de droit consulaire de 1955 pour connaître de la requête introduite par la République islamique d'Iran le 16 juillet 2018 et que la dite requête est recevable. Pour M. Yusuf, président, Mme Shue, vice-présidente, M. Tomka Abraham Benuna Cansado Trindade, Gaia, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge, M. Montaz, juge ad hoc, contre M. Brower, juge ad hoc.
I thank the registrar. Judge Tomka appends a declaration to the judgment of the court. Judge Ad hoc Brower appends a separate, partly concurring and partly dissenting opinion to the judgment of the court. The text of the judgment is available from today in TypeScript. It will also be available shortly on the court's website. The printed text will be available in the near future. As the court has no further business before it today, I declare the sitting closed.